major breaking news involving the Second Amendment out of Chicago. The United States Court of Appeals for the Seventh Circuit has issued a ruling against the Second Amendment plaintiffs. Specifically, as you recall, a 3-judge panel ruled against the Second Amendment involving the quote-unquote assault weapon ban out of Illinois. And it turns out the entire Seventh Circuit is going to do nothing to help the situation for gun owners. We're going to talk all about it when we get back. Hey folks, I'm Mark Smith, host of the Four Box Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and a nominee for 2 separate categories in the 2024 Gundy Awards, one for the top male influencer in the Second Amendment space, and also one of the top voices of the Second Amendment. I am proud and honored to receive these nominations from the 2024 Gundy Awards. All right, folks, so we have mixed news today. In many respects, this is bad news, but in the long run, it's not clear to me it's bad news, so let's break it down. The United States Court of Appeals for the Seventh Circuit, as you may recall, about a month ago, issued a major ruling against the Second Amendment arising from Illinois State's quote-unquote assault weapon ban, which is a ban on semi-automatic firearms, including long guns and some handguns, as well as banning magazines that hold more than 10 rounds. In a 2-to-1 decision, Judge Frank Easterbrook, who is terrible on guns, and Judge Diane Wood, who's terrible on guns, issued a 2-to-1 ruling over the dissent of Judge Michael Brennan that the Second Amendment does not protect the firearms that are banned by the state of Illinois, and that the ban of Illinois was not a violation of the Second Amendment. This is hooey for a whole bunch of reasons. Nevertheless, after that decision, a couple things took place. One is there was parties that sought rehearing en banc to the entire U.S. Court of Appeals for the Seventh Circuit. The way en banc works is, you have an initial 3-judge panel that hears a case, makes a ruling, and then you can request that the entire court, i.e. the entire Court of Appeals for the Seventh Circuit in this case, would hear the case again as an entirety. All the judges would sit on the case. So a request was made for a rehearing en banc to the Seventh Circuit, asking them to reconsider what the 3-judge panel did in the cases of Barnett versus Rowell and also Herrera versus Rowell, both of which were challenges in various aspects of the Illinois quote-unquote assault weapon ban. And today, the Seventh Circuit denied both requests for rehearing en banc. Specifically, the order essentially says that plaintiffs' appellees filed a petition for rehearing en banc on November 17, 2023. No judge in regular active service has requested a vote on the petition for rehearing en banc, and all members of the original panel have voted to deny panel rehearing. The petition for rehearing and rehearing en banc is therefore denied. So in the short run, this is bad news, obviously, because the whole Seventh Circuit is denied rehearing en banc. So at one level, that's a negative. That is true. But in the long run, it may or may not be a negative for 2 reasons. One is, keep in mind that there was another case that arose out of this decision by Judge Wood and Judge Easterbrook. That's the National Association of Gun Rights case versus Naperville, that is now before the U.S. Supreme Court on a request to to reinstate the injunction from the lower courts against the Illinois anti-gun laws. And that is pending before the U.S. Supreme Court. Justice Amy Coney Barrett asked for a response from the defendants and received one, and also received a reply from the National Association of Gun Rights. So the reason why this rehearing en banc is potentially negative is because if the Seventh Circuit heard the case en banc, it would suggest that they were not interested or did not feel like they wanted to defend the panel decision of Judge Easterbrook and Judge Wood, and there might be some judges on the Seventh Circuit that wanted to write essentially a opinion as to why the Illinois assault weapon ban was unconstitutional under the Second Amendment. On the other hand, it may be the case that there's enough anti-gunners on the Seventh Circuit that anyone interested in protecting Second Amendment rights on the Seventh Circuit concluded it was a waste of time to do so, and it was just going to delay this case even further. Because keep in mind, these cases, and this is very important as you analyze what's going on with these Illinois these Illinois quote-unquote assault weapon cases. Of course, assault weapon is a propaganda term. I understand that, but that's what this is labeled, so we have to use it because that's what the law is called for the moment. So with that said, this case is on an interlocutory procedural basis, meaning the case is not over. It is in the middle of the case. In fact, in many respects, it's at the start of the case because these cases were brought and immediately there was a motion for a preliminary injunction sought. A preliminary injunction is a request that says during the pendency of the case, the law that is being challenged is not allowed to be enforced pending the outcome of the case, which of course those cases can go on, as you know, for many years in the law. So we are still in an interlocutory phase of this case, meaning we're nowhere close to the end of the case, i.e. a final judgment from a lower court against or for the state of Illinois. We're in a preliminary part of the case, and that's why this is a motion for a preliminary injunction and not a final injunction, because again, the case is nowhere close to being resolved. The reason why this is significant is it is not unusual for the U.S. Supreme Court to want a final judgment to be entered before they hear a case, because they don't like to hear cases on what are known as an interlocutory basis. An interlocutory appeal simply means an appeal that's been taken during the middle of the case as opposed to after the lower court has finalized and issued its final ruling in the case, and the case is therefore done. So everything we're talking about involving the quote-unquote assault weapon ban out of Illinois, these are all interlocutory appeals, and in many respects that makes it harder to get, let's say, the U.S. Supreme Court involved, because again, they generally don't like to get involved with interlocutory appeals because they don't want to get it wrong on a preliminary basis. That's the general sense one has as to how the Supreme Court practices. So with that said, given the fact that the Seventh Circuit here has denied rehearing en banc, on the one hand, it does make it more likely marginally that the U.S. Supreme Court might take an interest in this case. Because keep in mind, the U.S. Supreme Court may look down at the Seventh Circuit and say, well, if they're going to hear this case en banc, we don't need to get involved yet. Let's just wait and see what the Seventh Circuit decides after their en banc ruling. But because the Seventh Circuit has denied the en banc request, and there will be no en banc hearing, and thus no en banc decision on the Second Amendment question involving the Illinois assault weapon ban from the Seventh Circuit, that is an avenue that's now foreclosed, which now basically says to the U.S. Supreme Court, it's you or nobody. It's you or nobody. So that is going to put added pressure to some degree on the U.S. Supreme Court to get involved with this case, i.e. in that pending case involving the National Association of Gun Rights. Now, I still think that's a tricky situation there because, again, this is an interlocutory appeal. And again, the U.S. Supreme Court tends not to want to get involved in a robust level at interlocutory appeal stages, which is what this is. But with that said, to the extent that this denial of the rehearing en banc helps anyone with the Supreme Court, it certainly would help the Second Amendment plaintiffs more than the defendants, because again, it doesn't give the Supreme Court the opportunity to say, let the Seventh Circuit work it out and then we'll deal with it after that's over, because that is no longer an option. And I should note that the lawyers for the National Association of Gun Rights, Barry Arrington, has already submitted a letter to the U.S. Supreme Court telling the Supreme Court about this decision, and thus again remind the Supreme Court it's them or nobody that's going to come to the rescue in the short run, the short term, for Illinois gun owners under the Second Amendment. So that's where that stands. Now, what is likely going to occur if the U.S. Supreme Court doesn't get involved here and enter an injunction stopping the enforcement of these Illinois gun control laws, the next step will be that these cases of Barnett versus Rao and Herrera versus Rao, and also presumably the National Association of Gun Rights versus Naperville, assuming that the Supreme Court doesn't get involved and they deny that request for an injunction or for an emergency stay. I won't bore you with the technical details, it doesn't matter. But if the Supreme Court refuses to get involved with what's going on in the lower courts with the Illinois cases and the Illinois gun bans, what will happen is all those cases will go back to the district courts, the federal district courts, which are the federal trial courts. And then here's I'm not going to get into the details too much right here, but here's the bottom line as to what I think will happen in those trial courts. The defendants, the government defendants, are going to try to delay the cases as long as possible. They will ask for 1,000 experts. They will ask for 2 years of discovery of the facts. They will ask for as long a period of time for these cases to drag out, and they will try to drag these Second Amendment cases out for literally 5 years if they can pull it off, thinking that perhaps the U.S. Supreme Court will improve if there is a change in the composition of the court, i.e. that something happens to Clarence Thomas or Justice Sam Alito, and therefore they can have Joe Biden or another Democrat replace them on the court, something along those lines, and thus make the court go back to not enforcing the Second Amendment anymore. That is exactly what the battle plan and strategy will be for the defendants and the government in these cases. It will be to drag the feet as long as possible. That will be their strategy as to how they do it. There's a bunch of ways they can do it. Only time will tell, but that is my guess as to what they will do, because it's delay, delay, delay is what they want until everything changes in this country, especially the Supreme Court. Now, I don't know what the Second Amendment plaintiffs are going to do, but presumably they're going to take the opposite approach. They're going to basically say that, all the discovery and all the information, all the facts and all the law is already on the table. We've already been litigating this for, onwards of a year. It's already gone up to the U.S. Supreme Court and to the Seventh Circuit. There's not a lot of new information here that needs to be figured out. These are really questions of law. What does the Second Amendment mean? The Supreme Court has already decided the Heller case, and they're simply going to apply this to what is understood to be ubiquitous firearms and arms, i.e. magazines that are held by tens of millions, if not hundreds of millions of people, and guns that are held by tens of millions of people. These are ubiquitous arms. They're clearly protected under the Heller test, and therefore there's no need for a lot of discovery. We can go right to summary judgment and move forward with the final judgment in this case, win, lose, or draw. That's what should occur. And on a related note, I think the Second Amendment plaintiffs can also point out that since the Seventh Circuit has already issued a law of the case laying out the relevant standards, and there's no real way for the Second Amendment plaintiffs to win under those standards set forth in the law of the case by that Seventh Circuit panel of Easterbrook, Wood, and Brennan, there's really no additional fighting that needs to occur, and thus I would think that the plaintiffs will take the position that they can move quickly to summary judgment and move the case forward ASAP, with a view toward going up to the Seventh Circuit and losing fast, and then seeking a request to the Supreme Court to hear the case on a cert basis on the grounds that, again, the argument will be down the road that now you have a final judgment in the case. Now you have a final judgment that says that these weapons can be banned under the Second Amendment, and now you have a final judgment in the case. You dramatically increase the odds of the Supreme Court to review a case with a final judgment. So the plaintiffs will be rushing out there, and my guess at least is the plaintiffs will be rushing out there trying to get a fast final judgment against themselves, because that will expedite the speed to get to the Supreme Court, and the defendants will be trying to do the opposite, which is to drag their feet as long as possible. Again, I don't know exactly what's going to happen. I'm speculating on that part. But again, if I were involved in that case and I was doing stuff as a trial lawyer in those cases, that's kind of how I would be thinking about it, depending on which side I was. Again, as to what happens, only time will tell. We'll keep you informed. All right, folks, so there you have it. We'll see what happens. We'll keep you apprised as things develop, both in the National Association of Gun Rights case before the Supreme Court and as to what happens in the lower courts in the Barnett and the Herrera case, all of which deals with these Illinois cases and these Illinois gun bans, and a lot more is going to occur, and we'll keep you informed as things do occur. And okay, well, hope you learned something here today. Don't forget to share and like this video and subscribe. Don't forget to follow me on X at 4 Boxes Diner, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.